the appeal in the name of PC.
Yes,
My
Mr.
lord,
Lawson.
my lady, today I appear for the applicant for permission to appeal and appellant this morning. My learned friend Mr Haddon appears for the ICB and my learned friend Ms Watson appears for
The official solicitor.
yes,
Yes.
absolutely.
Yes.
I was pausing in order to get the correct initial. I'm sorry. That's why I paused briefly. And with them are their instructing solicitors, Ms Stanley and Mr Edwards, and Ms Nicholas, my instructing solicitor, is with me, as well as Ms Gould, a pupil in Chambers.
Yes, thank you.
My lords, the first matter is the anonymity order.
Yes.
We have circulated that between council and submitted a copy of the order to the court.
Yes.
It is, I have copies with me if it would assist. If it would assist handed up, I have copies with me. There's two elements to it. We have combined the closing the file provisions of
Yes.
CPR 39.2 and 5.4 C and D, and the reporting restrictions elements. It reflects largely the order that was made by Mr Justice Cusworth when the matter was heard in April.
Yes.
That order was, however, time limited to expire 28 days after the end of the palliative care programme.
Yes.
My client intends, if it's necessary after today's hearing, to file an order to vary that in order to provide for permanent anonymity. So we have therefore, between the three of us, tried to provide an order to this court which requires the least amount of subsequent applications and changes.
So permanent anonymity in respect of all categories of person currently protected by the order.
Yes. Now, it's very likely there'll need to be an application to this court to vary that, but our proposal is that that Mr Justice Cusworth would hear the application to vary the order that he made, and we could then return to this court when, if necessary, findings of fact have been made for the decisions to be made about this order. We considered that an indefinite order was the best way to square the circle while that application happens, and of course pending a decision in Abassi and KCH.
Yeah. Well, we've no idea when that's coming. It was heard in April, as you know.
Yes.
But,
Yes. Anyway, so that's the order. It does have in it. There's one thing I should draw my lords and my ladies' attention to, which is that on it's not paginated. I apologise, but on page 4, the information extends at Roman 2 to professionals providing or managing care and treatment, and that's something that Ms Watson, on behalf of the official solicitor, has questioned as to why there should be such an order. And I believe in emails going around this morning that it's been agreed on behalf of the RHN that they don't pursue that any further.
Is that right, Ms Watson?
I understand that that is the RHN's position now. The official solicitor raised that simply because it was felt that the order was rather wide in covering unidentified individuals involved in management as opposed to identifiable treating clinicians and witnesses in the case.
Doesn't it correspond to the order made by the judge?
My lord, it does, and the official solicitor took the same position in respect of that order, but to some extent acquiesced in the sense that it does not directly engage PC's interests, and the order was limited in duration at that stage. What this court is being asked to do is to make an order that is unlimited in duration and goes therefore wider. Whilst the official solicitor would support an indefinite order in respect of PC and family members, the official solicitor is unable to support an order in such wide terms as to cover all of those named in the order indefinitely. That seems inconsistent so far as the official solicitor is concerned with orders of the same nature made in other cases, where certainly in relation to treating teams, witnesses and others, there is a more limited duration of order.
I was a bit surprised to see that the proposed permission to apply to vary is to us rather than to the judge. In the paragraph 14 of the draft order says that application can be made to us, but isn't it more usual to have application to the Court of Protection?
So that is an application to vary this order, and
Yes.
I think we've put it in on that basis because on the basis that the jurisdiction to vary the order of this court would lie with this court rather than with Mr Justice Cusworth. He will may have to vary the order that he has made depending on how he's minded on the application to be made.
This is all, it's all a bit philosophical, but does his order continue at the same time as we make another one? Seems a bit confusing for anyone
My
wishing
Lord,
to.
I've proceeded on the basis that it does. I don't know about my learned friends, that his order remains extant, covering his proceedings. And the reason we present an order at all, I wondered about whether we needed an order here at all, because there's an order below, and anything reported in these proceedings which identified people would necessarily be a breach of the order made by Mr Justice Cusworth. So I wondered about that, but we've presented an order.
I think one of the things that I'm slightly concerned about is I understand why, for pragmatic reasons, you've tried to limit further applications by making it indefinite. The problem is that you've then certain aspects of the drafting, certainly speaking for myself only, I see the problems raised by Ms Watson, because there's features of it that one would see very much in a time-limited order, particularly as we think the law stands at the moment in the light of Abassi. So on the one hand, you're making an indefinite order for pragmatic reasons, saying, well, just vary it. But on the other hand, we all know that really to make an indefinite order that includes little 2 and potentially little 3 of paragraph 10A are not orders we would now.
No. I mean, we are attempting to square a circle to provide for the smallest number of possible applications in the smallest number of courts. So we were drafted it on the basis that there would be an application before Mr Justice Cusworth, and then, of course, be a matter for this court to vary this order, but it might well be minded if the parties all agreed to follow any changed order of Mr Justice Cusworth. So,
If you're all agreed that Mr Justice Cusworth's order, transparency order, remains in force, then why do we need any order here at all?
my Lord, on my part, I'm amenable to the position that anything said about these proceedings would necessarily be a breach of the order made by Mr Justice
What
Cusworth.
often happens is that we simply say at the start the existing anonymity order
Continues to
remains
apply.
in force. Does everyone understand that? Good, let's get on with the appeal.
Yeah. I for a moment defer to my learned friends if they have anything.
Shall we do that then?
Yes, my lords, my lady, I appreciate this may be a philosophical contribution to this particular
Yeah.
argument, but I think procedurally a fresh order does need to be made, but it can be done in the terms as my lord has suggested regarding the adoption of the anonymity order below.
Well, can we make an order saying, for the avoidance of doubt, the provisions of the transparency order made in the Court of Protection on 23rd May 2024 continue in force unless varied by order of the Court of Protection or of this court.
Yes, well, the philosophical elements, well, perhaps it's more procedural, is that these are effectively fresh proceedings. The transparency order is in relation to those proceedings. The reason I'm making these submissions is I've had to navigate this argument in the upper tribunal as to whether decisions in a different jurisdiction, also around anonymity, also then extended to different separate jurisdiction.
We can make any order that the court below would have made, so why can't we simply adopt it?
Indeed, and that's what I'm suggesting. That a fresh order does need to be made, but in the same terms as below, as opposed to simply saying that the order of Mr Justice Cusworth remains in force. You yourselves have to independently make that order.
Can we do that? Yeah. Right. For the avoidance of doubt, we order that the provisions of the transparency order made in the Court of Protection on the 23rd of May remain in force. That means, as I'm sure everybody in this court knows, in particular, that nothing must be done to identify PC or MC. There are lots of other detailed provisions as well, and if there is anybody in court representing the media or anybody external who would like a copy of the transparency order made below, it can be obtained from the court office. Right, do we need to do anything else on that score? Right. Yes, Mr. Lawson.
Well, you should have a core bundle, a supplementary bundle and an authorities bundle.
We do.
We have between us, we started with a larger authorities bundle and slimmed it down, trying to pay close attention to the practice direction to only put in material that was in dispute. It's left me hoping that we put enough of the cases in, but there we are. By way of introduction, my lord, this case concerns MC, a 35-year-old woman who is currently an inpatient in a specialist nursing home provided by the charity the Royal Hospital for Neurodisability. MC was born in Turkey in 1989, moved to the UK in September 1993, so when she was about 4 years old. She attended school here and enjoyed it, and she and her sister were brought up by her mother. There was a prolonged period of estrangement from her father, but after the very sad death of her sister, the family came back together. And from about 2014, they started to see more of each other and get into more regular contact. After school, she studied fashion design and worked as a beautician. And at the time of her cardiac arrest, she was planning to study biological sciences at university with a view to working in an NHS laboratory. So at that stage in life where full of hopes and plans, still, you know, more thinking about the future and what she was going to do next and how she was going to live her life. She's recorded to have had an active life. She took care of her health. And she remained living with her mother through to age 35.
31.
Yes, absolutely. So in July 2020, she suffered a cardiac arrest just after breakfast. Compounded, if such a thing could be compounded, by the fact that it's her mother who found her. She heard a noise upstairs. She went upstairs and found her daughter. With the help of a neighbour, they called for assistance, called an ambulance, and that arrived about 6 or 7 minutes later. She was taken to St Bartholomew's Hospital for her initial treatment. The estimate was that she had a downtime of about 30 minutes, but of course these things are very difficult to estimate exactly. She moved to the Royal Hospital for Neurodisability in October 2020, and she was decannulated and began to breathe independently in February 2021. And in March 2021, she moved to the specialist care facility run by the Royal Hospital for Neurodisability. And she's been in a care placement since that time. Briefly jumping ahead, one of the factors in this case we say is that that is relevant, although it appears to be somebody who's in hospital. She is actually in a care facility, and the evidence of Professor Wade is that she could be managed in most care facilities. Ties in with the point about the burden of treatment. She currently has little medical treatment. The evidence is that she'd seen the general practitioner attached to the care facility once in the previous year. She had some time before had some issues with physical manifestations called storming, but those had ceased. So her treatment is largely by care assistants.
She is, however, in receipt of 24-hour nursing care. The
There's a-
evidence
there's-
was absolutely clear about that. Both Dr. A and Ms. B gave evidence to that effect.
Yes, although they agreed that it's a team, I think, of 3 care assistants and 1 nurse, and so relatively little nursing attention.
Well, is that right? When you're being fed through a peg, when you're doubly incontinent, when you can't move or talk,
Well,
or you can't do anything for yourself at all, to say
well, I mean,
there's-
the evidence was
care?
well, those matters were dealt with very much predominantly by the care assistants.
Yes, but it's nursing, the lady's point is it's nursing care, albeit delivered routinely when all is going well by care assistants. But I imagine there is a nurse on duty, isn't there?
That's my understanding, my lord.
So,
My understanding is there's 1 nurse and 3 care assistants on duty. I'll check the number of people before I
I'm
give
just
it.
struggling to. I'm struggling out how you can say that this is not someone in receipt of 24-hour care.
Well, 24-hour care, my lady, we absolutely accept. She is in receipt of
Well,
24-hour
nursing care,
care.
because it is nursing care. The care assistants do nursing care.
It's nursing-led care, if one likes. It's care not provided by nurses, so it doesn't largely require the skill set and training of a nurse to deliver it. I don't mean to try and play on words about which category it falls into. My point is more the stand back a little bit and say that this is someone across the range of people that we see who has, as the judge found, a limited burden of treatment.
Well, when you say treatment, you used the phrase a few minutes ago, medical treatment. She gets a lot of input from nursing-led care, but you say not much from doctors.
Yes,
Is that what it comes to?
yes. The doctor who gave evidence, I think, had seen her once in 8 months.
But we have the list of medication that she's onto, which presumably is governed by the in-house highly specialised GP that runs that.
She receives absolutely. She receives medication. She does receive medication, but the medication is maintained with 1 GP visit in 8 months. So it's. I mean, one of the points that came up and really everyone accepted is that the notes are repeatedly stating that she's stable.
Yeah, but define stable. I mean, I saw your skeleton argument about, and I've read everything, and stable is not perhaps in the sort of general way we express it. Stable seems to suggest that all's fine. It's stable against the baseline. So what that means that in her current parlous situation, she's stable in that she's not suddenly having unexpected, uncontrolled epileptic fits. That's the context, as I understand it, that we treat stable.
She's not. So her condition isn't varying minute by minute or over short periods of time. That doesn't require people to come in and assess the change and decide what to do about it. It doesn't require a burden of treatment on her to bring her back to stability. She's someone who, day after day, doesn't require the level of interventions that we sometimes see. If one jumps a little bit to ground 4, one of the, really our fundamental point in ground 4 is that these cases are brought in 2 situations, and in applying for permission below, I provided a list of the cases from the Court of Protection Law reports, which I can hand up if it would help. But I understand the difficulties of identifying individual cases. But it's striking that the cases refer to people with a heavy burden of treatment, often unstable, requiring a lot of medical intervention to maintain their condition, and often also recorded by the judges to be essentially dying, is the phrase I'm sure my lord, my lady will have seen in the judgments, that the person is already in a process towards dying. And that's one set of cases. And the other set of cases is where there's clear wishes and feelings. Perhaps the clearest of those is Briggs, where you had someone at a relatively early stage of their potential recovery from the condition, but the cases are otherwise replete with judges reaching conclusions that there's quite colourful language used, as you would expect when people are reporting colloquial conversations about what people thought about these things. Of course, the judge here found that there was no basis to reach any conclusion of that sort in this case. So the reason why we say stable is that in our submission, it takes this case out of the category of cases of the person who is requiring a heavy burden of medical treatment in order to maintain their condition. This is someone who isn't seeing a GP, isn't in a hospital, is receiving care from a team of people led by a nurse. I'm not trying to play with words about that, but generally not even from a nurse, and is receiving a lot of basic care. So dealing with incontinence or dealing with contractures are things that...
So your point is this, is that when one is looking to see, carry out the best interest analysis, in some cases, you have the patient, the subject, receiving so much care, that it is itself a burden and a factor to be weighed in the balance.
Yes, indeed.
That's your point. You're saying this is not one of those cases,
Yes,
where the burdens are such that it's a significant factor.
yes, indeed.
That's your point.
That's absolutely our point. And I don't want to completely jump onto ground 4, but just to give you the structure of that point, it then ties into the question about the sanctity of life, because if you have a low burden of identifiable wishes and feelings not to continue to live, the question that ground 4 raises is how then is a decision made to decide that that person's life shouldn't continue. So just to give you the structure of my submissions, I mean, the striking thing on preparing this case to me remained the change in the position from the expert witness, which underlies the appeal in ground 1 in respect of the adjournment. The position, the case was first listed for hearing on, I think, the 24th of March. The position at that point was you have 2 expert reports saying that she's not in pain. And of course, you're then potentially in the sort of to feed a Rakib position, where you have someone who's not, where it's paragraph 186, where it says not in pain, stable. The burden of treatment required to keep them in a minimally conscious state is low, and those were some of the key factors. There were others. Those were some of the key factors in finding that there wasn't a basis for withdrawing treatment from Tafida. So that's the position you are before March. And that changed in the run-up to or at the hearing. So our submission, it really doesn't matter which of those it was, because it was so close to the hearing that it makes no difference. It was also, of course, accepted that as a corollary of that, there would be an ability to experience pleasure, and there's a necessary implication for the level of awareness. So, and obviously I'll take the course to those points. So there's a very significant change. At ground 2, the judge was then in the difficult position that it was agreed that it was possible that MC could experience pleasure, but had or proceeded to make his own assessment of that. Tied into what one should do about that situation is the question of covert consciousness and the complexity of assessing consciousness. I obviously will recognise what the guidance says about that, and propose to take you briefly to some of the papers setting out that the context of the understanding of consciousness, and then go to the question about, well, how should the balance be drawn in that situation, presuming obviously therefore that we haven't succeeded on ground 1. So that's how I propose to proceed.
Yes.
There is, the guidance is in the authorities bundle. And there is, it's page 105.
You want to take us to page 105
Of the authorities bundle, my lady, yes.
Thank you.
And it's worth, I think, just spending a few minutes looking at some of these paragraphs together rather than going to and from the document. Just start with a useful guide. Always useful to see information set out pictorially, and there's a useful guide on 21 about the difference between different forms of disorders of consciousness and the difference between a terminal decline of consciousness. So the difference between someone who has a disorder of consciousness and someone, if you like, who is dying and their consciousness is fading as they die. And you can see the disorders of consciousness start with the person in essentially a comatose state of some sort, and then there's an improvement over time as the person becomes more aware. And it suggests that the context for the case is that people will remain dependent as they improve. That's what this graph shows. And you can see at the top, there is an indication of how terminal decline in consciousness works, and that's the precipitate drop towards death, a progressive and continuous and precipitate fall, which is a part of why we need to distinguish in our submission between different cases which are about end of life and cases which aren't, because of course people with a persistent disorder of consciousness are not dying. There are definitions on page 25 which show under MCS, the second paragraph in grey, MCS is categorised by inconsistent but reproducible responses above the level of spontaneous or reflex behaviour. And also above that, wakefulness, to the left of that rather, wakefulness with minimum awareness. Finally, just in terms of the useful introductory material, there is a I think it's 42. Yeah, it is 42. There's a very
Do you mean the internal 42?
I do. It's 126. There's a very useful differential diagnosis chart for the various conditions, and one can see the awareness, sleep-wake cycle, response to stimuli, and Glasgow Coma Scale scores, showing that people in MCS are aware they have a sleep-wake cycle, they respond to noxious stimuli. So if we go back one page to page 41, now moving into the more substantial material in the guidance, you can see under diagnosis, accurate diagnosis of VS or MCS is no longer critical for legal purposes, but is nevertheless required for clinical decision making and treatment planning. So Professor Wade responded a lot that it was no longer important to be accurate about diagnosis, but the guidance does say, as one would expect really, that it is necessary to.
Sorry, where does it say that?
Under diagnosis, accurate diagnosis of VS MCS is no longer critical for legal purposes, but is nevertheless required for clinical decision making. And under that, in the next paragraph, second line, the diagnosis is made on the basis of a careful clinical evaluation. And penultimate paragraph, misdiagnosis remains a significant problem and can be the result of diagnostic error or of actual change in the patient's condition, especially in the early stages. And in the next paragraph, for these reasons, evaluation is required by a multidisciplinary team of clinicians who are expert in assessing cognition, communication, and motor function. Key disciplines include physiotherapy, occupational therapy, speech and language therapy, neuropsychology, nursing and rehabilitation. And of course, in this case, over the last 2 years, all of the assessments that were done just by an occupational therapist. One of the points that concerned us about the evidence and part of the context for round one. If we go to page 47, you can see that this is under a section, begins at the bottom of the previous page, formal structured observational assessment and behavioural responses. So looking at the structured assessments that assist clinicians in making a decision about awareness and consciousness of pain and pleasure. And it notes 4 paragraphs up from the bottom of 47, formal assessment is essential in the following circumstances. In the third bullet point, as part of assessment when making clinical decisions about the potential withdrawal of active medical treatment. And on page 53, there's a table which sets out the issues about the various structured assessment tools.
Sorry, just picking that up. The initial assessment by Professor Wade, you'd say is inadequate to have carried that out. You say that the Professor Wade's first assessment doesn't satisfy that. Is that your case?
We can look at the report and the assessment, but that Professor Wade didn't carry out an independent assessment of awareness or pain, and I don't think he purports to in either of his reports. And he certainly hasn't used any of these tools, which are advised as a way of providing a structured and standardised assessment. That is, they've been done previously and the results monitored and compared to try and come up with something that's repeatable to give an accurate position. Professor Wade's report takes what had happened as a given, and as his starting point, takes the assessments that had taken place, which were 2 assessments, I think, in the previous 2 years, but we will look at it, by an occupational therapist. And his evidence was that that's sufficient. And we've seen that it should be a multidisciplinary team. We've seen it should happen before an application is made to discontinue treatment. The ICB responds to say it's not needed in long-term care settings, but that's a different context, looking at maintaining care over time in a care setting. We're looking here at whether or not we take steps to end this person's life. And that's covered independently by the guidance in our submission.
Is that how it was put below?
Well, it was put that the assessments that had taken place were inadequate, that they had to be done by a multidisciplinary team, that they had to be repeated. As part of why there wasn't sufficient evidence to proceed. We can look at the application too.
I've read it.
Yeah. So there's two parts of this table, 133. Sorry, I'm changing now between using the internal and the new numbering. It's page 49, which is 133, and it's not. It's page 53, which is 137. Sorry. The women, the CRS are. The other assessment is a SMART assessment. That wasn't used, wasn't an issue. Hasn't. We used to do. They used to happen a lot.
Right place.
Page 53, my lady, of the
Table about the utility and cost considerations
Yes.
of structure. Okay.
the reason is because it says how they should take place.
So SMART is no longer used.
Not very much.
WIM, as I recall, predated SMART. And at the time, for example, WM, SMART was thought to be taking over from WIM. But WIM has had a resurgence, hasn't it? Is that broadly what's
I
happened?
think that's right. The guidance says that if you're only going to use one assessment, use the COSR.
Okay.
I can't immediately take you to that, but I'll have it noted somewhere in my notes. But use the COSR. But yes, my lord, WIM, in my experience, one sees more commonly than SMART. But the guidance says that it's quite based on observational reactions, and therefore caution is needed with it. And our point here, what we draw from this table, is that these assessments have to be repeated. So they each take 20 minutes to document, formal testing of behaviours, 3 hours to do on 10 occasions, and then frequency and duration. The second part of that table on 53, CRSR and WIM assessments are conducted serially over a period of assessment to evaluate any trajectory towards improvement. Ideally, they're administered at different times of day, variety of positions, usually a rate of 2 to 3 a week. And then you can see that the CRSR originators recommend a minimum of 6 assessments over a 2-week period. And it notes below that training is not mandatory but improves reliability. And we've already seen that the overall assessment should be by a multidisciplinary team.
Sorry, can I just, I'm just trying to get the context of this absolutely clear in my mind. Dr. B, the consultant neurologist, who we've got the discharge report, and he, if my memory serves me right, said no further assessment need take place now upon the moving into the specialist care home that she's now in. I can give you the reference if you need me to take you to it. So I'm then working through in my mind, picking up your analysis. So in what circumstances then should further formal assessments take place once she'd been transferred to the nursing home? And you've taken us to to page 47, bundle 131, and it says initial diagnosis, formal review at the end of the expected recovery period. Well, you may or may not agree with it, but that was undoubtedly in the clinicians' minds the case, and that was why Dr. B said no more assessments once she was moved, because that was all done. And it's only in the course of this litigation that there's been any disagreement between the family and the clinical staff. They were all perfectly content, sad but content. So we're at little 3 that you took us to a few minutes ago. As part of the assessment, we're making decisions about the potential withdrawal. Yeah. So do I have to look at what was going on and what was happening in the context of what should have happened once an application was made? Why is how often WIMs were done and this, that and the other was done in the routine life of this poor young woman over the 3+ years? Why is that relevant? Because that doesn't seem to be the problem, and I didn't really pick up from first instance that what was being said was this was the problem, not what had been going on routinely. The problem was that a whole fresh assessment wasn't done for the purposes of this application.
Well,
I'd like to be very clear in my mind what exactly your case is on this.
It was that the court didn't have before it collectively. I need to come on, of course, to the change in position of Professor Wade, which is crucial for this. But the first part of it is that given that the expert evidence, if that's what it was, the second opinion evidence, has changed essentially 180 degrees.
No. It's changed on pain. It's not changed on her level of consciousness, her prognosis, the long-term consequences. It changed in relation to whether or not she was able to feel pain.
Well, and a recognition that pain and awareness would move in proportionate relationship to each other. That as one increased, so would the other. So that was a necessary impact.
Well, again,
on
I think you're going to have
We'll have
to take us to
Indeed.
precisely what
Yes.
Professor Wade said
Yes.
to support that solution.
Yes.
But at the moment, this is a run-up to Professor Wade.
Yes.
What else? What else do we need to look at in the RCP?
While
document?
we're here, Mr. Haddon wishes to take you to page 79,
Yes.
Thank you.
and it's the third paragraph.
It's 163 in the.
It's 163. Mr. Haddon quite rightly reminds me I'm doing it again.
The marked
Giving the internal page numbers.
Yes, this is, well, I didn't know that was there, but that was what I was picking up from
Yes, my lady.
Dr. A's
Yes.
report when
Yes.
I read it.
I mean,
Dr.
that's the-
B, I think, actually, Dr. B.
Yes.
Dr. A. Thank you. Right, so the breach of guidance, you say, is what?
So it is, what we say is that there isn't collectively before the court evidence on which it can make a decision. It needs to grant an adjournment in order to get more evidence, and that a crucial part of the context for that is that there hasn't been an assessment of consciousness done for some years, which is compliant with the guidance. So, and in fact, when you then look back at the earlier assessments, you see some higher level behaviours. So if you're taking the earlier assessments,
So no assessment of consciousness for some years.
which complies with the guidance to be using the standardised assessments in the way that they are standardised, in the way they have been prepared by the teams of people producing them, tested with groups of patients and found to be useful indicative tests to give an indication of consciousness and awareness. In order for them to function as tests, they need to be applied in the way that they're created, which is based on repetition by a multidisciplinary team.
How do you deal with the third paragraph on page 79?
The
Internal page 79, 163 in the bubble.
we say that is about providing care and attention to someone who's in a care placement, and for that it makes perfect sense. But it isn't about the situation that we have here, which is a court assessing is it fair to go ahead and make a decision about this person's life and death on the basis of the material we have. So that paragraph just isn't about that. Shall I, I will happily come back to this, of course, but if I go on and give the whole context, that may, and my lord has asked me to go to the Professor Wade material, and it may be helpful to do that as well.
Well, please don't be distracted from the course you wanted to take by anything I said.
No, and indeed. But yeah, so how we deal with that is we say that is about maintaining care placements. It is not about reaching an assessment of consciousness. Can we just briefly look at, really to introduce the material as much as anything else, at E1 in the supplementary bundle. So you can see that is a table produced, it would appears to me anyway to be a sort of secondary note based on notes made at the time, and you can see it starts in October 2020 on E1, and it records the administration there of a WIM test repeated on 10 occasions, and notes the number of behaviours observed and the most advanced behaviour observed. Over the page you can see a CRS-R test on page E2, again repeated 10 times, and it sets out the behaviours. You can see then in 2020 below that is, and you can also see that there's a number of people involved in administering those tests: speech therapists, occupational therapists.
Do we have the raw data on the following page?
We did ask for the raw data. That's why I say this appears to me to be a secondary.
Well, I'm
Why
looking
why
at.
do we need it?
Well,
But we have it. Don't we? What have we got on? What have we got on page
we have
E8 and 9?
we have some of it. I think whether it all
I mean,
tallies up.
not everybody would have seen these before, but
Yep.
So if we look at the highest tick, use that phrase, it's number 36 on 10, E10, which is what it says on.
Yeah.
That's what it says on page E1.
Yes.
The most advanced behaviour observed was on one occasion. She was seen to switch gaze from one person to another spontaneously.
Yes.
So we do have the raw data, don't we?
I think we do for that one. I didn't think we did for all of them, and I don't think we do for the later assessments.
This was the position at the end of 2020.
Yes. Should we? The last two we see on. If we jump forward a little bit on E6 and E7. there are some in between, so I'm just, as I say, really introducing the material. You can see there that you have a WIM test on 2 occasions performed by an occupational therapist in October 2023, and E7 CRS test on 2 occasions by the occupational therapist.
And do we have the raw material for those? The latest ones?
That's what I hesitated to say. I don't think so, and I was looking at E26 to E. Mr. Haddon may correct me. E37 says Mr. Haddon.
My E37's blank.
So is mine.
I think there may, and mine, I think there may be this.
All right, well, hopefully nothing's going to turn on
No,
the
I don't
contents of E37, but if it's worth our seeing and somebody has a copy of it, steps could be taken.
So
I think it's interesting, isn't it, to look at the raw data. Yeah, I'm not saying it's essential. But if you look at the raw data of the 2020 test, you can see the pattern, how often the ticks are there. And there, as you would accept, isolated examples of ticks on E9, the bottom part of E9 and E10.
yeah. Although my understanding is that one records the highest, the number of behaviours and the highest behaviour.
That's what those are the coordinates, as it were, actually, by the way, to get to an evaluation.
But yes, the highest behaviour was observed once.
Yeah. It's there, that's your point.
The application to adjourn was put on the basis that Professor Wade departed from the guidance and has changed his position on the perception of pain. We can go through it if you wish, but
I think if ground one seems to me to focus a great deal on what you say is a change of position
Yes.
by Professor Wade, at least on the issue of pain. And we'd better look at the critical pages of Wade 1, Wade 2, and then...
yes, I do intend to go to that.
Right.
I do, absolutely.
Should we do that?
It's where I'm going now, in fact.
Yes.
So, that he accepts pain and consciousness are positively correlated. That the understanding of consciousness is not fixed. And that if one can experience pain, then the withdrawal of clinically assisted nutrition and hydration becomes necessarily a more burdensome process than if one says one can't experience it. And the
Is that what
guidance
he
starts-
said, or is that a submission?
That was the basis of our application. So that was the basis of our application
It's
too.
your submission, not what Professor Wade said.
It's what the guidance. The guidance says that it can be.
No, but
a
I've
difficult
read the
process.
transcript of his evidence. That's not what he said in evidence, though, is it?
Our first point was that he departed from the guidance in a number of places. And, absolutely. So the first report, 17th of May 2023, is at D3. I obviously just intend to go to the relevant pages rather than introduce the whole report. So it's D19. Paragraphs, to be paragraphs 522 to 524.
Sorry, what paragraph?
522 on D19
Thank you.
to 524.
Yep.
And what we say, paragraph 522 shows his opinion that pain, pleasure and awareness are part of a common neural network and will move with each other. So these networks, plural, coincide with the networks responsible for awareness and consciousness. So one of the things I put to him was it's common sense, isn't it? He said yes.
You've got to put that together, I think, with paragraph 5.18, don't you? Because you've got to look at what the evidence was about awareness. Don't you? Because the evidence was that this young woman is not showing awareness.
Yeah,
And that's the consistent evidence throughout. And you just told us yourself that the high point level was seen once back in 2020.
But his report then becomes contradictory, doesn't it, in our submission?
No.
But because at this point he's saying awareness and pain go together and they're absent. And now he's saying awareness and pain go together. And if my lady's right, and one's present and the other isn't. But then he's saying they don't go together. We see while we're on this page, we see at 5:30 just his position on the impact of medication.
Sorry, what page?
Same page, D19, paragraph 5.30.
Thank you.
And then the second report comes a year later. The assessment is on the 27th of February 2024. And the report is the 7th of March, that's D24. And the relevant passages are on D38 and 40. So D38
Where?
D38 paragraph 3.10, that he explained to my client that the responses were reflex or automatic. And D42 5:16 to 5:18.
Well, could I suggest that we start at 5.9.
Yes.
Section.
Absolutely.
If this is central to your case, I think, in fairness to, well, I think
Everybody, yes. Yes,
So he begins by saying his comments remain valid
yes.
in the paragraphs you took us to.
Indeed. We don't say this shows a change. So we say this is maintaining the same position as in his first report. So his end point is the same in 518. He's softened it from very unlikely to unlikely, but that obviously doesn't matter for what it's worth. I've put the authority in the skeleton that one finds facts on the balance of probability. So his advice in this, his opinion in this report, is that she doesn't experience pain, and the explanation of that in 516 ties pain awareness. I'm just checking. Certainly, pain and consciousness together.
But he then says at 517, because pain is arguably the more basic phenomenon than consciousness, the pain matrix may be more resistant to degradation. And he said at 2.48 and 5.7 that she's not showing any awareness. And that would tie in that you may have no awareness, but may still be able to feel pain because arguably it's more resistant to degradation. So that's why it's, and having read that, it made me less certain of your submissions. Aha, that one goes with the other in the way you were putting it.
Well, he went. Let's have a look at his oral evidence.
Well, before we get there, can we just, if my lady will correctly, just pick up on her point. He doesn't say pain and awareness are the same.
No.
He says there, in this report, consciousness and awareness rise from a neural network of similar extent. And that's that's pretty well what he said in the previous report at 518, I think, or 522 actually. Where he says the pain networks coincide with the networks responsible for awareness and consciousness. So it's not they're not the same. They're coincident, or they are of similar extent.
Yeah, so it's a difficult concept. I expect for all of us to understand. It's not entirely clear what that means, and it may, to me anyway, I should say. I shouldn't speak on everyone else's behalf. It's always a mistake to do that.
So what I mean, in my imperfect way, I'm picturing parallel networks, or similar, is the word you use at some point, and on that for that reason, he says that damage that impairs one almost certainly impairs the other, or pain perception and awareness. And then on the other hand, because it's more basic, the pain matrix may be more resistant to degradation. So I think you have to be. This is not straightforward at all.
No, I mean, and indeed, one of our points it is the uncertainty about consciousness, which means we need to proceed with
Sorry,
great
what
care
uncertainty?
about what it is and how one measures and identifies it. That is our ground 3 about covert consciousness. That you can have people who show no behavioural reactions, no physical behavioural reactions, who show mental activity in the brain.
There's
But
no
let's-
evidence to that effect.
No, well, no, I mean, it hasn't been looked for, and I've recognised that the guidance says that it shouldn't be a standard clinical practice. So, and I respect the guidance. I'm not trying to go behind it. But it's a complex area. What it is to be aware and how one measures it. My lord, parallel is a word I would resist because
Yes,
of
no,
course
it's not the right word.
because two parallel lines never meet.
No, you're right.
And whereas coincident
Yes.
conceptually may be better, but is inevitably less clear. It's harder to know exactly what that means, whether it's coincident in the same space in the brain or in some other way. Should we have a look at the? I don't.
Well, you cross-examined on this, didn't you?
Yeah.
That's right word, that's the verb.
Yes,
You asked questions about it.
I did. And I mean, they are set out in the replacement skeleton argument, but it's paragraph 24 of that, which perhaps, if I can hand it up if need be, but it's
Of the skeleton.
of the replacement skeleton, and we can go to them in the document. So the first one was actually with Mr Haddon, D68 E to F
Sorry. We're in paragraph 24 of your skeleton.
of the replacement skeleton.
I
my lady.
don't have a replacement skeleton. I only have your application for permission to approve.
Your mind.
One is on the way.
Thank you.
So that's
One is, are you taking us the transcript as well?
Yes, D68.
there's a good slab of transcript in your skeleton.
There is, and that's at paragraph 24.
Yes.
Thank you.
That's what you're going to focus on. But it'd be useful just to know.
Have that to one side and then see them in the
No,
context.
it isn't. Yeah.
Yeah.
Right.
Yeah. Mr. Haddon, is it?
This is Mr Haddon. So at D refers to the first report. Mr Haddon asks, is it still your view she's very unlikely to be experiencing pain? No. You can't rule out the possibility. I'm suggesting words to you. That's not my current view. And then he explains that he's changed his view. And then cross-examination begins on D71. And then at F, your second report, you say it's unlikely she's experiencing any pain. What I've said, it's unlikely, but not unknowable. And then the next
Not
answer,
knowable that she is not.
yes.
Sorry, I interrupted you.
Not at all. So I then put his former conclusion to him. You'd say it was unlikely, but we can't rule out the possibility. And he says no, basically. Having done some more research, it's difficult to say she's not experiencing pain. And I say that's a change of position, and over the page on D72 he said yes. confirm that he's not seen the patient again. And then at C, you have to separate the extent of the experience against the experience. I would say it's possible, indeed probable, that there's some sensation of pain, but I can't say what it would feel like. And then at F and G, he says that the paper, we haven't been to the paper, we can do. My solution is the paper doesn't say this, but it doesn't really matter. And he says he produced the paper in the immediate run up to these proceedings and because of these proceedings. And it was about a week ago, he thinks on the 17th, so about a week before. Didn't obviously get to us the very day he wrote it.
But it did get to you in advance of the hearing, I hope.
It did I think a day or two before I can check. But if need be, we'll go to it. It doesn't say what he said here.
Where is it for my note? Where is it in the bundle?
It's D51. It starts on D51. And our point is that it gives arguments for and against something. It doesn't say anything about this patient or actually change a position. It just says on the one hand, on the other hand. Nothing wrong with that, but it just isn't the same as this.
Yeah. Were you then going to take us more in the transcript?
Yes. It's 74.
Before you go to 74,
Yes.
do you think you could just look at 73C?
Yes.
What I'm trying to say is we have to separate out whether she has an experience and then the extent of the experience. I think she has some experience, don't know whether it's small or large. We can't know. We can't go very far talking about it because in the end I can't ask her and you can't ask her, no one can. We have to go on her behaviours. Now, when I read that yesterday or the day before, I thought that was taking us back to what was clinically observed, which were the very much increased number of times that she was observed to be crying and distressed, if I can put it like that, and that she responded to antidepressant medication. Now, am I wrong in the way I've analysed that? And if so, could you help me with it? And
Now, my lady, my understanding is that he's drawing on those two factors. But of course, each was present when he wrote his previous reports, and he went out of his way to explain that they were automatic behaviours and to speak to my client and to say, no, they aren't indicative of things.
no, but what he's saying at the end, you're saying he's completely changed his view. But I want you to help me with this passage because I thought that what he was saying was, yes, I have changed my view. I do think there is some pain, but actually, we haven't got the first idea how little or much that might be. And at the end of the day, all we can look at in a best interest decision is what we're seeing.
Well,
now, if I'm wrong, please correct me because I want to be very clear about how you're putting your case.
well, we say that is a change of position because he's had the same presentation before and gone out of his way to say it doesn't indicate pain.
But he's saying ultimately pain is not the issue.
In what sense the issue? I mean, it's a part of the best interest assessment, and but it is also we'll go. It's also that he accepts that she can experience pleasure.
Can you show us that?
Yeah. But can we, just before I go to that, We just in passing D76. It's H left. And the answer, I've thought about it now, it's probably wrong in the past. Now that's a striking position in our submission. This is someone who's been on the specialist register for neurodisability since 1996, who in the weeks before this hearing says I was wrong and I've completely changed my position. That's a highly material factor then whether further investigation needs to be done to see what it is about the circumstances or medical knowledge of this patient that has led an expert, I think, is in 11 reported cases, to say, oh, look, I've been wrong. Now I've got a different view.
Why does if it is a change of position, why does that necessitate further investigation of PC?
Because it's a change of position about a fundamental part of the decision before the board. It's tied into the question of awareness and having other experiences, and it's in a context where there's limited wider evidence.
But from what you've shown us so far, from what I've read, he's not saying I've misread and misdiagnosed the 11 cases. I misunderstood what he said is thinking about it and what I know about it. That is my view of whether or not it's likely or unlikely that they experience something of the nature of pain in these circumstances. My thinking has changed. He's not saying the evidence has changed. So what would you learn? What would we learn from a further assessment which would inform the best interest decision?
We would first of all have an opportunity to remedy the sparse supporting evidence and
Supporting evidence of what?
of the patient's degree of awareness and consciousness, and the key in that sense the key question. And we would have the opportunity to hear the position on pain and pleasure and awareness tested as against the views generally of neurologists, and the opportunity to get the further evidence that would hopefully allow us to try to make some progress in resolving these questions, rather than to have them diametrically opposite each other in our submission in the space immediately of when the case is being heard. Indeed, after the case had first been listed for hearing, the case would have been determined at the end of March on a very different basis.
But there hasn't been any change in the available material as, if one puts the issue of pain to one side for a moment, awareness of consciousness, responsiveness, and so on. You showed us the primary source records, question 26, tick in the fifth column, and so on. None of that has changed. What you're pointing to is Professor Wade's opinion on the issue of awareness of pain.
I mean, indeed, I mean, in a way, it should have changed. I mean, the proper response to moving, I opened with the paragraph from Tafida Rafiq in which it was the reasons for maintaining the patient were given as an absence of pain and the fact that she's stable and easily maintained, along with other reasons. So on a fundamental point, there's been a change of position just before a hearing. So that, in a way, my lord, our position would be, well, there should be additional evidence, rather than saying, well, that hasn't changed. It's right that hasn't changed, but the interpretation of it has turned, and that requires us to think, well, if our interpretation is so fluid over weeks without seeing the patient again or getting any more information about the patient, how can we confidently go ahead and decide about this person's life and death?
But his change of mind is not based on the interpretation of whim assessments, is it?
It's not. No.
So why would the carrying out of a further assessment of that sort or any of the conventional sort? Maybe you're not arguing for that, but why would that wouldn't affect? That has no relation to his change of position. His change of position is almost a philosophical change, as it were. A high level change of view about whether or not people in disorders of consciousness feel pain. It's not based on reinterpreting the metadata, is it?
Well, it has consequences for the other two big questions. Should we look at what he says about that?
Yes.
D86. At D. Consciousness and pain perception will increase proportionately. That's a reasonable assumption or hypothesis. More aware or conscious someone is, the greater the experience or whatever the experience they receive will be. I accept that's reasonable.
I think we need to read on.
Yes, and the more pain someone experiences, the more likely they are to be conscious. I don't think if you're going to then say the more pain behaviour you see, the more conscious one is, I don't think that necessarily follows. But that's back to dealing with pain behaviours. What he said is that she's aware of that pain. He talked about pain behaviours in his first report and said this is just pain behaviours. And what he's saying now is no, there's awareness as well of pain. There's perception of pain, whatever you want to put it. It's beyond automatic reactions or nociceptive pain. It is an experience of something. That, as I understand it, is his change of evidence. And then D108F for Freddie. Down to F. Sorry, is it F? I'll just give you a moment to read on to middle of 109. And that ties into awareness in a couple of ways. I mean, one thing it says that she's reactive to the environment, and the other that she's reactive to certain people. While we're here, just the page before D107B, I mentioned that PC is in a care environment, and you can see at the top A to B on 107. Professor Wade says needs to be in. So the nursing required is beyond what could be done at home, but it could be done in various care homes. I mentioned that our application to adjourn to obtain further evidence opens, in fact, by saying that Professor Wade departs from the guidance. And I'll just, if I may, I'll give you those references and take you to those places. It was in quite a few places. D78C.
I'm not saying you have to, but if we have the written application, that you might have it all written down.
No.
No,
So-
you didn't.
I'm sorry, because we didn't have the transcript, and obviously the judge had just heard it,
No,
and
all right,
and then it was made orally, but we
carry on.
D78.
78 at C. For the shall I just, for speed, if I take you to the 4 points, I accept there are questions that could be asked about the extent of it, but let's look at them together.
Yes.
D78C, you can see the answer, no, it's wrong, and the guidance is wrong to say that misdiagnosis is a problem. And he's saying not in, because it's about VS or MCS. But of course that's important because VS or MCS is about the degree of consciousness and awareness. So he differs from the guidance on that. D80C. Noting, I put to him that the UK guidance requires you to have repeated assessments, and at C he says that the originators were practicing in the context of the United States, so disagrees with the need for repetition.
Does that tie in with what we looked at in the guidance about once you're there and everything's going along relatively smoothly, then you don't do...
Well, what we're asking here is about the need to repeat at all, I think.
This is why I got confused about the context in which you were putting all of this.
I mean, what we were saying was that in order to have a compliant assessment under WIM or CRS, there has to be repetition. And you've only done an assessment if a standardised assessment, like a reading age assessment for a child, has to be administered according to the protocol for the test. And the UK guidance picks up and adopts the protocol, which says a number of occasions, and
but it says, I'm really sorry, I'm really struggling because it says, we looked at it together at page 163, you don't require to do that when they're in a permanent state. Although it's good practice to conduct a brief annual follow-up, which we saw in October 23.
But in order to have, if one's going to say that there is a CRS or there is a WIM, it needs to be done repeatedly. And one can say, well, we no, you only need to do it in 2020.
But that doesn't even tell you that you've got to do a WIM at all. It just says you confirm with the family or the care staff there's been no change and you enter the information.
Well, that is talking about maintaining someone in long-term care. Well, it's not, though, because here what we have is an application to cease treatment.
No, but you were putting, as I understand it, in your cross-examination, that there'd been wholesale failure to comply with the guidance in the care of this woman.
Well,
and this young woman. And actually, as I understand it, now better from your very helpful oral submissions, is that what you're saying is that it would be in the context of an application of this type that a full assessment, rather than saying there'd been wholesale breaches of the guidance by this specialist nursing home.
what I think I was trying to say is that there wasn't before the court a proper basis on which it could reach a conclusion about the degree of consciousness because the administration of those tests hadn't complied with the guidance. And
They had, because she was in long-term care and you didn't have to do it.
well, subject to, I mean, that bit of the guidance is guidance about keeping people in long-term care and how often.
Thank you. So you were taking us through the breaches of guidance, and you said DA.
Well, the disagreements, the points where he differed from the guidance. D8, there's two more. D81D.
D81B.
D. The guidelines were written. He says that the context is he says that the guidelines are out of date. I was just trying to move to the end point, but I think one does need to look at D80 G to H to understand the exchange. So I'm then, my lady, picking up the point about the need for repeated assessments.
Well, I've read the whole of that through, and what he is saying is that the need for repeated assessments is in particular in the early stages in the diagnostic purposes, and that once you've got 4 years down the line, whatever it may be, it's no longer necessary. And then the longer answer he gives at CDE on 81 explains why how the thinking has moved on.
Well, yeah, I mean, he says that it's not necessary for court, which actually probably is the inverse of what's right.
What do you mean by that?
Well, he says, doesn't he, that in D81D, when the guidelines were written, there was a major emphasis on the level of consciousness. He means in court, going back to the SMART assessment period.
Yes. Isn't he saying retesting as to precisely what signs of consciousness there may be is not necessary, not the focus now. You look at on a broader basis at the best interests.
Yes, I think that is what he's saying.
Where in cases where you have no suggestion of a change of consciousness, you don't retest after the first period. That's what he's saying. Well, first of all, am I right? Is that what he's saying?
I don't think he was making that final point. I was hesitating. I was thinking, well, does it arise from what he said? But I think the first point, he's saying that you stand back and make a best interest decision. But that has to be in the context in our submission of an understanding of the person's condition. And so the way the question for the court, actually onto the ground, is, well, what is it fair? Was there information before the court that allowed it to reach a decision about this patient's condition?
Well, is there any statement of principle that there has to be up-to-date evaluation of the level of consciousness before the court can make a decision of this sort? By up-to-date, I mean recently
Yes.
repeated.
My understanding of the train of the cases, and so I've got a list of 11 decisions which I can hand up, maybe useful just to have for a reference, is there was a period in which the courts did very much require that, and almost all these cases came in for a directions hearing, which resulted in an order to produce a SMART assessment with 2 neurologists meeting together, and the neurologists were sometimes asked to have other people on the team with them in order to carry out the assessment, and it took a period of time, allowing for the process of doing it and writing it up months. And then it was decided that that wasn't necessary there were decisions both at High Court level and at Supreme Court level.
The Aintree case where there was the check.
Or was
in
it
particular paragraph 39 of Baroness Hales?
Or was it why?
Well, why? why.
The Intensive Care Society intervening.
The 2008 Supreme Court decision, I think, is the case that Mr Lawson is referring to, and NHS Trust and why. It is referred to in the agreed legal principles documents, which, my lord, my lady, you have at A12 of the supplementary bundle.
Right.
Oh, yes. 2018.
2018.
Yes, you said 2008.
Oh, I'm sorry. I was being, I think, numerically
Dyslexic.
dyslexic. I was going to say that, but I thought it was probably incorrect.
I was thinking Lady Black when you said.
It was indeed
well,
Lady Black
and
2008.
2008 through.
I meant to say 2018. My lord,
That's
there
po-
is
now that is post entry.
it is. There is also reference within that agreed document at A21 to Mr Justice Peter Jackson, as he then was in Re M in 2017, making essentially the same point. As I say, A21 of the supplementary bundle. And by the same point, I mean the point that is made in response to Mr Lawson, that is, further investigations may take matters a little bit further, but really how far does one need to go when applying the appropriate test?
And of course, part of the answer to that is the Lambert and France point that in order to be compliant, it's a matter to be dealt with within each country's jurisprudence, but it has to be a thorough process. So, at the general level of abstraction, if someone says, well, you can always investigate more, the answer is, well, you have to investigate quite a lot, and at that level of abstraction, in our submission, that doesn't take us very far. So that's the context. The judge dealt with it at paragraphs 41 to 45 of the judgment, and really had 3 points. Is it perhaps? Would you like to go to it?
Yes, please.
That is on page C52. Sorry, it's 51, 52 on C57. I'm sorry.
Paragraphs 51 and 52.
51 and 52. Which essentially make the points that no uncertainty about diagnosis in the fifth line of 51. The element of uncertainty is pain and discomfort in 52, and half to 2/3 of the way down 52, no evidence available which indicated prospect might be functioning at a higher level. by way of response, just as we look at them, no uncertainty in diagnosis. I mean, it's not uncertain that she's in a persistent state of persistent disorder of consciousness, but the extent and nature of that is, we say, uncertain. That because there's been a change from whether or not someone can perceive something, saying they can't, to saying they can, and that pain and a recognition that with that would come awareness of her environment and awareness of other
Sorry,
people.
that's not evidence. That's not what was said. That's not what was said. All the evidence is that there was no awareness, and Professor Wade was very clear that pain may subsist longer after an ability to feel any awareness has gone. And the medical evidence is very clear there's no awareness. And you've taken us through it, and that's the evidence.
And that's the point about we were having an exchange about parallel or whatever the right way of describing it. But whatever it was, it's not the same. It's a similar network. Is there anything to support the proposition you just made, which the lady is challenged?
What we're doing is ultimately making a decision as to whether or not the proceedings were fair.
Absolutely.
And we say if you bring together all the factors that we've identified, that required the opportunity to obtain further evidence about the awareness of PC and about her experience of pain and pleasure, and that it is surely fundamentally unsatisfactory to determine something of this importance for her, of course, and her mother on the basis of what is essentially shifting sands that directly, immediately before the second time that something's listed, fundamental parts of the evidence change. I would submit that that's clear from a very unlikely to a definitely yes. So one then is left, my lord, my lady, with well, what's the nature and extent of that change?
Mr. Lawson, you were showing us the judges, paragraph 51 and 52. It would help me if you tell me what's wrong with them. I appreciate the procedural point. I've got that on board. But which of the things that the judge says in 51, 52 are wrong?
Well, my submission was, and I was pausing to talk about the nature and extent of the evidence because I'm grateful for, and I understood my lady's interjection to say that that's not how the court reads. The way I put it isn't how the court reads the evidence. So I was pausing to respond to that. I mean, our position was that there was uncertainty about the diagnosis. And because that's something more than being in a state of persistent disordered consciousness, it requires us to have an understanding of pleasure, pain, and awareness. Now, I mean,
Oh, forgive me. What is the uncertainty about the diagnosis? When the judge said in 51 there was no genuine uncertainty, on what basis did you say that was wrong?
well, our submission anyway is that it's a fundamental part of identifying the condition that a patient with disordered consciousness have is to identify the extent of that consciousness and the disorder of it.
But this arises out of what it all arises out of what you say was the change in Professor Wade's evidence.
Combined with the lack of other supporting evidence. I mean, the neurologist, I think Dr. B, hadn't seen the patient in a clinical capacity for 3 years. The other evidence was about care presentation, so it really was the only evidence about her state had, in our submission, on any basis significantly changed. Now, it may be, my lords, my lady, that on looking as clearly have carefully through the evidence that I haven't been able to persuade you that there is a change, that change amounts to a change in diagnosis.
Well, what you've
As
got
I'm
is
seeking to do.
sorry,
No, as I'm seeking to do, but
what you've got here, you've got two things. You're saying A plus B equals C. So A is the lack of up-to-date evidence of the sort we've been talking about. B is Professor Wade's change, and you say therefore C is an uncertainty of diagnosis.
yes. I mean, not, of course, I'm not suggesting that one has uncertainty about whether it's a persistent disorder of consciousness or even whether it's MCS. But I mean, it depends a little bit on what the word diagnosis is doing. In our submission, it isn't just the same as saying whether someone has cancer or diabetes. You're talking about the nature and type of that cancer and the stage to which it's progressed. Talking about whether or not the person needs intervention in order to support their kidney function. So it's something more specific, and that specific information has significantly changed.
Yeah.
That is our submission.
Yes.
So that's my lord, the first
Excuse
one.
me, could you just go? My lord asked you to what parts of 51 and 52 do you say were wrong? And you say the judge was wrong to say there was no genuine uncertainty about PC's diagnosis.
Yes. For the and wrong that the only uncertainty is pain. My lady obviously makes good and appropriately challenging points about what we say came with that. But on any basis, the expert is recognising that, I think it is at one point accepted that it's common sense, that pain, pleasure and awareness are related to each other and proportionately related to each other. As one goes up, the other goes up. As one goes down, the other goes down. So we say that he did go beyond in those two areas, just saying it. He said it was about pain, but recognised that there are consequences to that, like being aware of saying, yes, I think she probably is aware of her mother. And that I don't think is in either of the reports, that idea of awareness of people or place. But he says she is aware of people and place. Now, I recognise I may not have established enough, but that in any event is what I would, that point I've just made is what I was seeking to make out. It may be on clearly a very careful reading that I haven't got that point home, but that's how we present it. And then no evidence she might be functioning at a higher level. Well, I mean, the change from no awareness to the 3 points I've just mentioned is a change, and then back to fairness, it's an unsatisfactory position, and I'm not meaning that to be obviously to be personally critical, but it is an unsatisfactory position that. For the second hearing of the matter, it would have been dealt with entirely differently on the first. For the second hearing of the matter, the person saying that since that first listed hearing, my view has changed on an important point. And that means that, I mean, the court's being asked to reach the same conclusion on what, in my submission, is one of the most important points in these cases, which is the burden of treatment. Indeed, there was a time when the idea of intolerability was almost put forward as a touchstone for everything.
Well,
That's long gone.
Lady Hale deals with that.
No, absolutely, but it's long gone. But it's clearly the burden of treatment is an important point, and the position on the burden of treatment has completely changed over that time, because it was, if you're not aware of any pain, then the burden of treatment is arguably zero. Whereas if you are aware, the burden of treatment is different.
Going back to your submission, I think you were saying that the judge's assertion in 52, further there was no evidence available to indicate any real prospect that PC may be functioning at a high level, than assessed, was wrong. So what evidence was there that there was any real prospect that she was functioning at a high level? You were referring to the subsequent tests, are you? The 2023 tests.
I mean, first of all, the points that we put forward, we say are themselves evidence of functioning at a high level. It's also, of course, he recognises that the fact that she's on sedation, which has been increased, will change the outcome of assessments anyway. I took you to the points in his reports. And he says in his evidence that all of the medications she's on, he then says, oh no, there's one of them, I think carbachystine won't, but all of the medications will have a sedative effect on that. Which makes assessment difficult. And of course, as I understand it, there's very little difference between as what's in Mr Haddon and myself as to the law. It's an assessment of fairness to be carried out by this court, and of course with the well-known basis of the robing room is full of tales of unwinnable cases that were won and unanswerable charges that were answered and inexplicable conduct that was fully explained. So it's that if we look at what are the reasons to go ahead, this isn't a case where there's a heavy burden of treatment on the patient. If one looked, for example, at AH, in which I appeared in front of my law 18 months ago, that was a case in which the patient is having to be kept warm. So that, I won't go through all of the burden of treatment, it's in the various reported decisions, but a really very heavy burden of treatment. It's not really said here, that's a reason to go ahead. So the reason to go ahead is essentially the point really about, if you like, court resources. It's about timing, efficiency of litigation, of judicial determinations. But there isn't really another reason not to pause and take stock in our submission. So if one's balancing fairness, I mean, what what are the factors to argue for proceeding? They are that decisions need to be made. That's really the factor.
Does it come to this? It seems to me almost you're having it both ways with Professor Wade's evidence. That you say he changes his view on whether it's likely that the patient is suffering pain. If the fact that she is suffering pain is to be used as a part of a justification for withdrawal of treatment, then you should have been given the opportunity to challenge it. Alternatively, seem to be saying, if he's right about the experience of pain, he appears, you say, to have conceded that if a patient is experiencing pain, it's quite possible that she's aware of her environment and the presence of her mother, possibly even experiencing pleasure, though to me as a layman that seems unlikely, but anyway, that's what you say he said. And if he's right about all of these things, then the whole case needs evaluating because the judge has simply got the balance wrong. So are you putting it in both those ways?
It's really that there needs to be an opportunity to test the position that he's arrived at, rather than, I mean, one can see ways in which one can turn that proposition around. I mean, the starting point for the appellant would be, well, it's said that if she isn't experiencing pain and therefore reaction to treatment, it's in her best interest not to continue being treated. And if she is experiencing things, it's in her best interest not to be treated. So the position in terms of the application remained exactly the same, whether or not she was or wasn't experiencing. And that, of course, is quite something, again, for a party to the case to understand as to how something important can be said to change. So that requires investigating.
Right. Have we covered ground one? All right. Let's go on to your other grounds.
My proposal would be to be relatively quick about ground 2 and to be slightly slow about ground 3 and 4. And I would hope that I could deal with grounds 2 and 3 before lunch.
Right, keep going.
Okay, the others do need a go.
Yes. Let me.
I think you said 2 and 3 went together, or
Yeah, well, they sort of lead backwards and forwards into support of 1 and support of 4. So I just pause for a moment as I think how we've covered a lot of ground. I don't want to repeat any of it. So we've seen and looked at the point about being aware of the environment and her mother. And the question then is, well, what's going to be concluded about pleasure and indeed contentment? And my lord, in W and M, part of the decision in that case focused very much on contentment as being in itself a valuable state of experience. It's at paragraph 43 on C53. Can I give the court a moment to read that?
Sorry, what are we in?
The main bundle, the core bundle.
Are we in the judgment?
Yes, paragraph 43 is where the judge deals with that question of pleasure, contentment and awareness of others.
you cover this very succinctly, if I may say so, in your skeleton argument, paragraphs 52 to 56.
My lord, thank you.
Have a look at that and see whether it needs any embellishment or addition.
Yes.
Sorry, no, I've got the paragraph. No, I'm sorry, I've got the paragraphs wrong. It's the wrong
42, not
skeleton
52.
Yes. Sorry.
Oh, no, I think I would largely simply be setting out orally what is in writing, and we've seen a lot of the underlying material.
Yes.
And I can move on, I think, to ground 3.
I think you probably can. Yes,
Thank
I'm sorry. That's so ground 3 is 46 and following.
It is. And that, worth, I think, looking at some of the underlying material about the studies and then at the guidance. So it's the authorities bundle 285.
These are the papers provided Adrian Allen, aren't
They are. And as I say, I'm going to take you to how the guidance deals with this and pay respect to the guidance, but it's useful first to see the material before we look at how it should be dealt with. Of course, there's a large amount. We had more papers before the court below, and by the nature of it, there's lots of papers. What Professor Owen has done, is to try to find another way to talk to people, to communicate with people who are in a state of persistent disorder of consciousness. And he explains on the middle column of 285 that just as we reason from a behavioural response to awareness, so he says we can reason from brain activity to awareness in the ways that he gives. And the reason then why it's called covert consciousness is because it's not apparent from behaviour. So people are assessed as not being conscious. And you can see in that middle paragraph, he talks about working with a patient. When we asked her he's using a functional magnetic resonance imaging machine, so he's taking images of the brain as he asked the person to carry out activities. And when we asked her to relax, top of the middle column of 285, activity in this premotor cortex, this area of the brain diminished. We've seen this many times in healthy participants, and we were asking them to imagine playing tennis. And then we asked the person to imagine moving from room to room, and we had a very different pattern of activity in the brain. Different parts of the brain showed activity. And just at the bottom of that paragraph, on the basis of these fMRI findings, we concluded that our patient was not vegetative at all, but conscious and aware, despite the fact that she'd been entirely physically non-responsive for more than 5 months at that point.
Could I interject here and
Yeah.
ask what's the status of this material? So these are research papers that you put to Professor Wade.
Yeah.
You didn't call an expert.
No.
Is this peer reviewed?
I believe so, but I can't, in that it's an academic journal. There's from a number of academic journals. The material, so the material is reflected in the guidance, which recognises that it has scientific meaning. Don't we?
What does that mean?
Well, I could take you to it, but should we look at it first and then?
Are you saying that this should have been adjourned in order for someone to try and find an fMRI scanner?
No. What we're saying is that it shows the complexity and uncertainty of consciousness, and that's why when I said that we are respecting the guidance, we can start with the guidance if you like. But the reason why I said that was exactly because of course I could see that question as an entirely understandable question. What you see in the third column, middle paragraph, is suggests that there's a significant 17% figure is given there. Uncertainty, of people who appear not to react behaviourally to in fact show signs of awareness.
So just how large was the group? What was the control group?
The collective, I mean, subsequently one of the papers says that there's been a
The 17% was of a group of patients. Sorry, just how big was the group?
that I don't know, but I do know they later referred to 37 studies with more than 1,000 patients. Shall I show you the two others and then?
Yes, I'm still worried about the status of this material. I gave judgment in a children's case a few weeks ago about the use of research literature in brain injury. And this was material, you didn't call a witness. You put these documents to Professor Wade and he commented on them. What's the status of this research material in that context?
I mean, we're using the material to inform a question about what to do. We're not suggesting that you should make findings of fact about it, of course.
So don't we start with, should we not start with what Professor Wade's, not necessarily start, but a major element of this is what Professor Wade said about this, because that was the evidence before the judge.
Yeah.
Or you say that this is fed into the guidance as well, so you
Yes.
may be able to.
It's reflected in the guidance. I will we can go to the guidance and to Professor Wade. Just while we have the pages open, shall we look at? Oh, we don't have to, but shall we look at this while we're at it?
Well, can my lord and my lady know more about how these cases are dealt with in the Court of Protection than I do, but I mean, are you referring to this to say that the hearing should never have gone ahead because research shows that this is a very complex subject, very difficult subject, and were you trying to say that it's unsatisfactory to reach a decision about any patient unless there have been recent full assessment tests?
No, my lord, I can't say that because the guidance doesn't say that.
Yeah.
Let's have a look at the. I've emphasised a couple of times, but it is important, and I think it's important for me to say it and be clear about it. I'm very clear about the fact that I'm not inviting you to go behind the guidance. So
Right.
Why don't we go to the to the guidance.
We can reread Mr Owen's paper if
Yes.
you would like us to. Now, just be clear then, this paper post-dates the guidance. At least it seems to, because on page 286 it says May the 8th.
What happened is there are lots of papers underlying this, as you can see. I used a later one because it brought all the other.
This is the one you relied upon.
Yes, but I deliberately used one that brought together all the other material. I'm just trying to find you the page reference in the guidance.
The guidance.
Yeah, sorry, I'm just trying to. Sorry, I had it listed earlier. Bear with me. I think it's internal page 54. It is. So it's 138 of the authorities bundle. mean, one of the things that troubled me about this when presenting the material and when questioning Professor Wade, not the question my Lord very properly asked me, but the question of how we find what's the scientific consensus on these questions.
That's why I asked whether it was peer reviewed.
So, I mean, that troubled me. It troubled me in questioning Professor Wade. Continues to trouble me. And of course, it reflects the point, as my Lord says. Well, where's the witness to explain it? And that's why, amongst many other reasons, why I say I do and I have to respect the guidance, because that is produced by a number of people and carefully drafted and redrafted and so on. So. In my submission, what this shows is a recognition that this approach to working with consciousness, a little bit like the word parallel, I'm trying to find the right word, is valid, and I'm working for exactly the right word. It says in the paragraph, the second paragraph under brain imaging.
Where are we now? Forgive me.
Authorities 138.
Sorry, I'm sorry. Forgive me. 138.
Authority 138.
Sorry, forgive me. Sorry to distract you. Yes.
It's fine. So, so that is what the guidance says about imaging. The summary, the conclusion, is the final paragraph on 139.
But before we go that, the number of challenges.
Yep.
Whilst it's acknowledged there is a small cohort of patients who present behaviourally as being in VS but demonstrate covert responses, the prognostic significance is as yet unclear.
Absolutely. But that doesn't affect the point, of course, that we're still dealing with someone with a different degree of awareness, someone who will be aware of, if you like, who may be aware of what is happening to them. So they're not saying, my understanding anyway of it is they're saying prognostic in the sense of recovery rather than, it's like they're not saying the diagnostic point is unclear. And then at the, in summary, the overwhelming consensus of clinical commentary and peer review, so that picks up on that point, is that more advanced brain imaging and electrophysiology techniques have provided valuable insights into this patient group and will continue to provide important focus. However, the evidence base has not yet reached the point, not yet reached the stage of development where these could be considered part of routine clinical practice. More work is required to improve our understanding of how these investigations should be interpreted and how they contribute to decision making. And as I say,
And the next sentence.
sorry, I stopped innocently, but I'm sorry. At present time, it remains unclear whether they are capable of informing the diagnosis beyond detailed clinical and behavioural assessment over time, and whether they have any prognostic utility in the early stages post-brain injury.
So the proposition I put to you, Mr. Lawson, is that in effect is what Professor Wade said in evidence when you asked him questions.
So, I mean, we weren't, but it was asked, were we saying that we should stop to carry these out? No. It wouldn't be right of us to have said that they should stop to carry them out because it wasn't supported by this material. So what we were saying is that what this shows is that the existence of an assessment of human consciousness is recognised by the people producing this guidance to be more complex than behavioural techniques alone can show, and that should urge us to caution. So,
at the present time, it remains unclear whether they're capable of informing the diagnosis beyond detailed clinical and behavioural assessment over time. And the judge said that's what's happened in this case. And the clinical and behavioural assessment over time has shown that the diagnostic to be correct and that there's no awareness.
well, as I say, we weren't arguing that they had to happen. What we were saying is that the fact that there are these techniques recognised as valuable and giving information tells us that again, I'm trying to choose the word perfect, people can be, and there are various percentages given. The next page gives slightly different various percentages, but a not insignificant number of people whose awareness is not well reflected in behavioural tests, and that should urge us to caution. This is not an area we understand well. It's an area where technology is giving us new insights, and all those things urge us to caution. That's our fundamental point.
Well, those propositions by themselves may be correct, but how does that get you to ground 3 of your grounds? Sorry, just wait a minute. Sorry.
Mr. Haddon, sorry, asks if you would read over the page to finish the summary section.
We will in a moment.
Yes.
Yeah.
All right. So we should read up to the end of 2.4. So the 2 paragraphs
Yes.
over the page. Right. We'll do that. All right. Mr. Lawson, I'm certainly anxious to hear from you on ground 4, and it may be that you've given ground 3 all that ground 3 is capable of having.
Yes.
It's quite a short point. Should we go on to ground 4?
Yes, my lord.
Yeah. Right.
So, I'm happy to do that because ground 4 in my submission is a particularly important one.
Yes.
Mainly in the sense that I leave the court with the list of cases that I had, trying to go through every case where there's been a decision about persistent disorder of consciousness. This ground is essentially based on 2 findings in the judgment. And C58, paragraph 55. Just give you a moment to read the paragraph.
Paragraph 55.
55 and 58, beginning, her family make it clear that.
Yes.
Yep.
Ending obviously with the conclusion that there's an absence of a clear steer about her wishes and feelings. And then on 58, I do bear in mind that there is no need for PC to receive any especially burdensome treatment. They're not the only 2 points relevant to this submission, but the submission is that both wishes and feelings and burden of treatment don't point strongly in a direction of ceasing to provide treatment. There will be more of these applications coming. I say that for 2 reasons. One is the case of GU, references in my skeleton, said that people who are in PDOC need to be reviewed regularly to decide whether to continue treatment. And the other is that the evidence before Mr Justice Cusworth was that RHN had on the basis of the case of GU, had begun a review of its patients, and there are, my understanding, from those involved in them, quite a few applications coming into the court of people who had been in a stable state of receiving artificial nutrition and hydration, and had not up to the point of GU proceeded with any application to remove treatment. Mr Haddon and Ms Watson will probably be able to give you more information about that, but I'm fairly sure it's right that there are more of these cases coming because of GU, and there was a challenge from Ms Watson in this case, which to the speed at which that process was happening. On behalf of the official solicitor, she said decisions should be made more quickly. And very sensibly, if I may say, didn't pursue that in front of Mr Justice Cusworth in order to focus on the decision in this case, rather than to look at the overall process. But a lot of evidence was filed about it before Mr Justice Cusworth. So that will lead to a different pattern of case coming forward. Now, the response to our saying, well, what's the reason for stopping treatment? My Lord, as the M was, Mr Justice Baker in W&M, and Mr Justice Charles both looked at cases and tried to find set themselves the challenge of finding a reason for overcoming the sanctity of life and the importance of maintaining the
I don't
person's
think they were
life.
trying to overcome the sanctity of life.
Yeah, so that's why.
At least I hope they
That's
weren't.
why I changed it to say set themselves the
I'm
challenge.
taken aback by that submission, but I
Set
can't speak for
themselves
Mr
the
Justice Charles.
challenge.
I know what you were trying to
Yeah,
say.
set themselves the challenge of whether they could.
Well, the sanctity of life was and remains an important criteria. Very important.
As was recognised by the judge.
It was recognised by the judge. But the question is, what was it? Neither of the two bases in the cases for overriding it, for finding that it shouldn't be the basis of the decision in this case, in our submission, was present.
So
Someone
you're
with-
saying if you can't ascertain wishes and feelings, and someone has 24-hour nursing care in the ways described, but they're stable, then there should not be withdrawal. Ever?
With
Is there any temporal, 1 year, 5 year, 10 years, 20 years?
well, time
I
shouldn't.
just want you to crystallise your submission.
I mean, time shouldn't matter. Shouldn't be the case that if the simple passage of time is a basis for changing the decision.
Mhm.
That, given the absolute centrality in common law and ethics of the sanctity and importance of human life, and of course in the European Convention, that there needs to be identified a robust reason for overcoming that. In Briggs, Mr Justice Charles, paragraph 71, looks for a compelling and cogent case that this is what this person would have wanted in order to reach the decision in that case. In the other cases on withdrawing treatment for people with a persistent disorder of consciousness, apart from looking at their wishes and feelings, there's been a focus on the burden of treatment. But neither of those factors are applied in this case, and it's not clear that the response that is made by the respondents is, well, Aintree answers the question. But Aintree isn't a case about the end of life. Actually, the applications are not end of life applications, they're ceiling of treatment applications. And it is a case for someone who is in a parlous health state And the conclusion given in the first case to reach the Supreme Court about this Act of Parliament is at a very general level of abstraction. It is, of course, the classical starting point of every best interest assessment, but it's not the end point of every assessment. We are trying to work out the best interests of this patient. It's not a substituted judgment test, but these are very general statements. If we are going to give the respect that we say we give to the sanctity of life, it isn't just a factor to put in the mix. And the other factors that are identified need to provide a firm basis. I mean, compelling and cogent was the language of Mr Justice Charles. Firm, robust, clear basis for saying that that step, self-evidently a final step, an irreversible step, for something so fundamental to common law, the convention, and our value systems, has to have a firm, compelling, cogent, whatever the word is that one uses, has to have a robust basis for reaching that conclusion. And it's striking where you say, well, there isn't really a heavy burden of treatment, and we don't know what the person thought, to go on then to say, but there's a basis for bringing their life to an end. And that appears, both for the reasons I've given about GU case, to be something that hasn't been before the courts, and having tried to search, all the examples I came up with fell into a different category in which there was a reason identified. So, if you like, where you have a very fine balance, if you sort of seesaw analogy, at one end of that fine balance is a very great weight, or a weight sitting further from the pivot point, or whatever you want to, all those games we used to play, and that needs to be respected and identified as a basis to overcome something so important. And as Mr Justice Cusworth said, we pointed out the approach that was taken in W&M, not to looking for a reason to overcome the sanctity of life, as you rightly say, but the approach that was taken in that case, recognising the narrow benefits, narrow gains that someone with profound disability can have, but recognising their importance, the dignity of being cared for and loved and concerned about, even in that case for someone then with MCS. And I, for this different purpose, thought if I end just before lunch, if I may then just take instructions about whether I continue after lunch, but just take you, if I may, to a different paper, and we're not particularly going to make medical points about it, but there's two things in it that I found compelling. I'll give you the reference and tell you what the data says. It's a paper on locked-in syndrome, again communicating with people. And it asked people with locked-in syndrome what they wanted. And there's a number of things, but the most striking of them is when asked if people would like CPR, 62% of people said yes. And I found that a challenge to my own perceptions about disability and the value of life and what people would want, and a compelling piece of information about people's preferences. And the paper has in it a really neat little fable from Aesop, and I'll give you the reference for it. It's 298, and it's somebody who is seeking rest, and they put down the burden they're carrying and says, my playful terms, I'd give anything for rest. And Death says, well, I can help you with that. And the person says, I'll pick up that burden again then. And that, from Aesop, reflects that same idea that we would continue.
You cross-examined about locked-in syndrome.
Yes, I'm not trying to suggest a parallel between locked-in syndrome and persistent disorder of consciousness. I didn't cross-examine about a parallel between them. I cross-examined on the preference.
You're trying. Are you saying that because locked-in people said 62% wouldn't want withdrawal or resuscitation, that we should apply the same to someone whose wishes we can't ascertain?
I'm saying that both the fable and the data are.
You can't apply locked-in data to this situation.
No, but both the fable and the data I found compelling indications of the value that people place on being alive. That it's simply that point. It's simply that point that people choose, whatever the phrase is, the worst, most burdensome form of life. My lords, my lady, that probably is a convenient time for the short
Yes.
adjournment.
Yes.
And thank you for hearing me and helping me move to and from the points that were useful to you. I'll take instructions over lunch as to whether there's anything further for me to say, but it may very well be that I can just reply as appropriate.
2 o'clock.
Yeah, well, they go out and